Welcome to another edition of Question and Answer with a Criminal Defense Attorney. My name is Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about habitual traffic offenders, or HTO. But before we get to that, don't forget to click like if you're enjoying this video and subscribe with a little bell next to it to be notified of future videos. Let's get to the question. So, habitual traffic offenders, or HTO. I like to start with a statute because it explains exactly what we are looking for. So, here we go. Habitual traffic offenders. It defines the type of offenses that you have to accumulate within what sort of a time frame to be declared HTO. Let's take a look. So 7 years or 5 years. Two sections here. Subsection 2 talks about the list of major traffic offenses. It's just an easier way to call it is just major traffic offenses. Like, for example, DUIs, driving in a reckless manner, driving under revocation, knowingly making a false statement, vehicular assault, any conviction that results in death, like careless involving death. Careless involving death is a 12-point offense that will also suspend you for points. But here, look at my other video on points for that. 12 points is bad. But these all have to be 3 or more convictions within 7 years to be declared a habitual traffic offender. This other section here talks about just having a bad driving record. Think of it like that. So the subsection 1 is about major traffic offenses. Subsection 2 is just having a bad record. In other words, 10 or more 4-point violations within a 5-year period will make you a habitual traffic offender, or 18 or more 3-point or more convictions will make you a habitual traffic offender. I mean, that is truly just having a bad record. And what does that mean? Here, just slightly different, easier way to see it. 3 or more major traffic offenses within 7 years, or 10 or more 4-point, or 18 or more 3-point. So in other words, that is the major traffic offense, or the just bad traffic record. And what does it mean to be a habitual traffic offender? Your license will be suspended for 5 years, and you will not be allowed to reinstate your license within those 5 years. So it's a pretty harsh license suspension. And obviously, if you drive while you're under revocation, if you're not allowed to drive and you drive, you will get what's called a criminal habitual traffic offender charge. And that's where the second section here, you can be sentenced up to 24 months in jail just for driving while being a habitual traffic offender. So these are fairly draconian penalties, but that means that you really have to avoid major traffic offenses, and you have to not drive if you've been declared a habitual traffic offender to avoid jail. Because if you are convicted of say, driving under revocation for being a habitual traffic offender, you will almost certainly be facing jail. The only question is how much. So. Oh, and the other thing is, if your final revoking event, like say, for example, you've got a reckless driving and a DUI, and you just got convicted of another DUI, and all of these happened within 7 years, you will be declared a habitual traffic offender. But if the last thing was a DUI, you will probably be eligible for an ignition interlock because the express consent law for DUI allows that. So at least there's one good piece of news on this type of question. So that is the question and answer for today. If you would like your own question answered in future videos, don't forget you can put them in the comments below. Email me or put it in tag me on Twitter. And as always, you have a right to remain silent. If a police officer asks you questions about what you have, what you know, where you've been, or anything, you have a right to say, I don't want to talk to you. And if they persist, you can always ask for your right to an attorney.